So my students call me Professor Hoag, but I am a lecturer in law at Columbia Law School. I'm also an associate research scholar there. And I was excited to be named the inaugural Eric Holder Practitioner in Residence at the Eric Holder Initiative for Civil and Political Rights, and that's housed through the university. And so my charge is to bring these issues of social justice and racial justice to Columbia law students and Columbia college students. And that's after a decade of spending as a civil rights and criminal defense lawyer, mostly in Nashville, Tennessee, with the federal government, and then also with the NAACP Legal Defense and Educational Fund in New York. And so it's been a real privilege to teach the lessons I've learned as a civil rights lawyer to my students, to this next generation of movement lawyers and actors for social change.
I really like this idea that you had in your article that said that the law of slavery was uniquely American invention because the common law that the colonies inherited from England did not provide for master and slave person relationships.
Yeah, and it's not that slavery didn't exist in other parts of the world. We know it did, but what it produced here was unique.
Right, and could you kind of speak to a little bit more about how that thread kind of continued through?
Yeah, and so when slaves were brought to the enslaved people, I try to be conscious of using people first language because slavery was a status. It didn't define the person. So the people that were enslaved that were brought to the colonies in 1619, in the beginning, there wasn't clear categorization of how they should be sort of treated in culture, where they fit in sort of in the hierarchy. And so what I want to make clear during our conversation is that it wasn't just the stain of slavery that's impacted the way that our laws operate in the United States. It was the racial hierarchy that resulted, that then continues in society and politics and culture today in the United States. But when they were brought, there wasn't really clear demarcations between, the early colonizers, enslaved population, later indentured servants, the Native American population. But then there's always conflict when you've got people from different backgrounds coming together, and there needed to be a way to organize and to create some sort of order and hierarchy, as I mentioned. And this was done primarily based on race and, of course, gender. But we'll be speaking primarily about the hierarchy that was instituted based on race. And so there were very early laws, slave codes, that dictated the type of conduct that would be considered criminal. And it often specified the race of the perpetrator and the race of the victim, so that there would be certain conduct that when committed by an enslaved Black person would be considered criminal. So I'm fast forwarding a little, but in Louisiana, the territory of Louisiana, if a white person was struck by an enslaved Black person, the Black person struck their master and drew blood, that was considered a capital offense. So the death penalty was the punishment. However, if a white person struck an enslaved Black person, or really just a Black person, it could be a free Black person, that's often not a crime. And so the very early laws in this nation, in the before we were a nation, would allow white people to assault, brutalize, rape Black people with impunity. And in fact, the only means of redress for crimes committed, acts, I should say acts, because they were not considered crime, but acts committed against enslaved Black people were reimbursement for the white slave master. And so you could be reimbursed for damaged property. You could be reimbursed for the loss of property should that enslaved Black person die as a result of that conduct. And these were laws that existed throughout the colonies and then throughout the states after independence, 1776. And so you had laws in Georgia. Rape, not considered a crime when committed against a Black person, yet punishable by death. I'm speaking specifically in Georgia, there was a statute. And again, this was across the colonies. And so after emancipation, slave codes turned into Black codes. And this was during this window of Reconstruction. And following Black codes, you had this long reign of racial terrorism and Jim Crow. So racial segregation in all facets of society. And within the law, and just late last night, I was reading the US Commission on Civil Rights report in 1965 that was documenting the widespread white supremacist backlash against the exercise of Black votes and Black rights. They were looking in Mississippi specifically and collecting testimony in Jackson, Mississippi. And they actually identified law enforcement as being at the center of a lot of the violence committed against Black people, and then law enforcement not providing a means of redress for Black victims of crime, which is what my article is about, is the victimization of Black people and the lack of redress, lack of access to the courts, lack of access to justice, despite these constitutional amendments that have been in place since Reconstruction that actually recognized Black rights, but was really just existed in name only for well over a century.
Yeah, we, in our group, we talked a lot about the history of police in America and policing, and kind of where it came out of slave patrols in the South, and in the North, it came out of kind of the protection.
Labor organizing. Yeah, it was a way to break labor organizing, was to pick up laborers for minor infractions, so they literally could not come together and organize.
Right, and can you speak, since you read that, since kind of 1965, we think of the police kind of differently as not being so white supremacist, but it seems like, and the FBI said 10 years ago in a report that white supremacist groups were infiltrating the military and police. So maybe if you could talk about like kind of how we got to today, and the Black Lives Matter movement and the defund the police kind of idea, if you're comfortable talking about that.
Yeah, John, these are big picture questions. And so I can offer a little bit of illumination and perhaps pose additional questions for your membership. As you correctly identified, law enforcement really derived in one of two ways, which largely in the South was through slave patrols. And this is actually embedded in our U.S. Constitution. A lot of folks don't know that, but there was a fugitive slave provision written into the Constitution that basically deputized private citizens to re-enslave, capture and return, kidnap and return Black people into slavery. And this concept of deputizing private individuals was really what early policing was. The first municipal police force was not established until 1838, and that was in Boston. And of course, the federal government developed the U.S. Marshal system, later the FBI. But as an institution, law enforcement is actually quite young. And so when you hear these calls to dismantle, defund, abolish police, it's a younger institution than slavery. And so when we think about abolishing an institution, it doesn't sound nearly that radical when looked at in context with abolishing slavery. But to get back to law enforcement and the culture of law enforcement, which is really what we see as problematic today, I want to return again to slavery and the institution of slavery and this concept of the racial hierarchy that was created as a result of slavery. And the fact that as part of that racial hierarchy, Black people, brown people, were equated with criminality and dangerousness. So there's a presumption of dangerousness, a presumption of criminality when encountering a Black or a brown person. And the way that laws were created, the way that the criminal legal system, and I use criminal legal system instead of criminal justice system because our system is far from just. But the way that the criminal legal system disproportionately impacts Black and brown people is a direct descendant of that presumption of criminality and dangerousness that is given to Black and brown people. And so today, law enforcement, when you look at the use of force and lethal force in some instances, when you have police officers that encounter a Black or a brown individual, there is that presumption of criminality, the presumption of dangerousness. So even though George Floyd is not resisting, He is laid out on the pavement, handcuffed, held down by two other officers, physically restrained and not resisting. You have this lethal force given that presumption of dangerousness. And so George Floyd really had to be a Black man. Eric Gardner, Tamir Rice. And that presumption of not just criminality and dangerousness, but also assigning adulthood to children. Tamir Rice was a child. Black girls, Black boys that are social science research, that society views them as older, needing less protection, less nurturing, that they have higher thresholds for pain. All of this is directly descended from the racial hierarchy and our institution of slavery.
I like your term of racial hierarchy because it takes it out of the kind of white supremacist backlash that white people say, well, I'm not white supremacist. No, but we live in a racial hierarchy.
Yes, a caste system. We have an American caste system, and that's not talked about enough. And the fact that, you know, in South Africa, they can go through a reconciliation on apartheid. We had apartheid in this country. And we organized people based on identity, based on this racial hierarchy. And until we have that collective recognition of what happened in this country, what continues to happen, and the legacy of those things, we can't move forward as a society.
One of the things that came up in our discussion, and I think people are interested in, is kind of this idea that while Black communities are seemingly over-policed, there's also this, you know, criminality within the communities. And some of that does draw from redlining and their oppressed communities economically and socially. But it seems counterintuitive that while there are more police, there's actually more crime. And maybe you could kind of speak to how that works.
I'm so glad, John, that in prefacing that question, you mentioned redlining and structural inequality. And the communities that you speak of are under-resourced. And that's the common thread. And so it's unstable, unsafe housing, it's food deserts, not having access to high quality, healthy food, not having access to public transportation, reliable public transportation, not having access to healthcare, to mental health care, to robust programming for young people. So much of crime can be attributed to lacking access to basic necessity. And that's why I mentioned that list of the lack of access to these everyday needs of people. And that can't explain all of crime, but it can explain a good bit of it. And so when we look at the safest communities in this country, they do not have the most police. The safest communities have the most resources. And so this idea of defunding police, what would that even look like? It would look like the suburbs. And it's not that radical of a concept. And really what the calls, the mass demonstrations, not just in this country, but around the world, we're calling for is a reorganization and a restructuring of power. And so right now, the power is in the hands of law enforcement. And these calls to dismantle and defund and abolish police are really about strategically reallocating power and funding into the hands of the community. And people who live in police communities know intimately what it is to be safe and how to be safe. And if they had the funds and the power in their hands, they could do a much better job of creating a safe environment and having alternatives to the criminal legal system to deal with any issues that arise. And this concept of having a militarized outside sort of police force. So many of the police officers don't come from the communities they police, but having outsiders come in armed to the teeth. And the culture of policing is very much to be at war with communities. That's not sustainable. And the mass demonstrations, you know, have shown us that large segments of the population are not will not continue to stand for.
So you, I wanted to talk a little bit more about prisons. And so maybe you could talk a little bit more about how like a white person and a Black person's experience within the criminal justice system, from arrest to imprisonment, is different. Because I think we get the idea that like, if I commit a crime and someone in my demographic, who's Black also creates a crime, we're treated the same. And I'd like to kind of hear your thoughts on that.
Yeah, dismantle that sort of myth. Yeah, and it starts immediately. And I actually want to back up with the hypothetical. If a white person, a Black person commit a crime, I want to take it all the way back really to birth in utero, and the different sort of resources that are provided to most white Americans versus Black Americans, and this idea of being under-resourced and lacking basic amenities. The infant mortality rate and maternal mortality rate for Black women, regardless of income and education level, is astronomical relative to white women. And in fact, it's a greater disparity for the highest educated Black women relative to highly educated white women. And so this comparison, I really do want to start it by backing up, and having access to high quality education, and having access to attainable education. And there's social science research that Black children are tracked in non-college bound courses, in non-sort of gifted and talented programming. The Yale Child Study Center has an eye tracking study that actually teachers begin tracking Black boys at an earlier age to look out for behavior that they categorize as misconduct. And when you look at sort of the misconduct of children and discipline of children in schools, it's generally for Black children subjective behavior. So when a child brings a weapon to school, that's clear, that's objective, okay? That is something that needs to be disciplined and taken care of. But Black children are often disciplined for subjective behavior. They're talking out, they're disrespectful to teacher, they're being disruptive, and Black children disproportionately are targeted for out of school suspension, are targeted for expulsion, and then higher rates of Black children, once they are expelled, don't have access to educational opportunities. They're actually cut off from education as a young person. And the police that we have in school, when you're a hammer, everything looks like a nail. And so police in school actually funnel children, mostly Black children, into the criminal legal system immediately. And so now, John, if we have a white person and a Black person committing a crime, chances are that Black person already has a record, possibly from as a child in school, because they were pushed out by a school resource officer that didn't send them to the principal's office, but send them to the Cayuga County juvenile court system. And so now this person has a record. There are rates when looked at in terms of policing that police officers stop, question, and frisk Black people at higher rates. And actually the quote hit rate, so it is legal, it's an Ohio case, Terry versus Ohio, that allows police to, when encountering what they determine as reasonable suspicion for having some sort of weapon or contraband, they can stop, question, and frisk an individual. And so there's research showing that the hit rate of actually securing contraband, securing drugs or a weapon is actually higher for white suspects, because police are actually using their discretion, as opposed to encountering Black suspects, Black individuals that they suspect are engaged in criminal activity. The hit rate's actually lower. And I'm speaking primarily of my experience litigating against the NYPD in New York City and their stop and frisk policy, which a federal judge found to be unconstitutional because of the way the police were employing it against Black and brown individuals, mostly boys. Young people in this city, and so the encounter with police officers, already there's anti-Black bias being imposed, anti-Black racism playing out. And then in terms of the the prosecutors, the county prosecutors, were determining what to charge an individual, whether it should be an aggravated offense, or because now we know this person has a record, whether to charge them as a habitual offender. And so they're then susceptible to higher, longer sentences if they are convicted, or whether or not to charge them in state court or federal court. I practiced as a federal defense attorney in Nashville, Tennessee for almost a decade. And even though I was doing post-conviction work, my colleagues doing trial work, so many of their clients were Black men who were charged federally as a felon in possession of a firearm. So this is someone that has a felony conviction from their past. They've done their time, they've been released from prison, and they were found to have an unlicensed firearm in their possession. And I want to remind your membership that possession doesn't necessarily mean in your hand. It can mean in the car that you're riding in a group of people that you're with. And prosecutors, the Cayuga County prosecutors can decide, okay, should we prosecute this in state court? Or should we hand this off to the U.S. Attorney's Office so they can prosecute it in federal court? And the decision to prosecute that in federal court, you cannot divorce that from race. And the consequence for being a felon in possession of a firearm, depending on the person's record, which we know also has racial bias to it, is upwards of 15 or more years in prison, in federal prison. And so it's really a myth that, with an encounter with police, a Black and a white person will be treated the same because their history is not the same. And then what happens to them once they're in the system. There are studies that show that juries, there's a study done by Jennifer Eberhardt out of Stanford called Looking Deathworthy. And the more phenotypically Black a suspect looks, a defendant looks, the broader the nose, the thicker the lips, the darker the skin, the more likely a jury is to sentence them to death for the very same crime, for the very same aggravated type of murder. There's studies that show that judges sentence defendants for longer periods of time when the defendant is Black. Juries, as I said with Jennifer's study, with that presumption of criminality and dangerousness. So it touches the system at sort of every decision-making point. And you have all of these actors in the system, police officers, prosecutors, juries, judges, that are empowered with discretion. Because we're human beings within the society, within America, we can't help but factor in race. We are socially conditioned to factor in race. And because of the racial hierarchy and the fact that we haven't had this reconciliation, this reckoning with slavery and the stain that exists, the legacy that exists, we haven't moved from that. So thank you for that question. I think that's a really important issue to explore.
And maybe if we could kind of wrap up on your the death penalty work you've done, where instead of you make an interesting argument for the abolition of the death penalty. Maybe you could kind of explain that a little bit, kind of for the layman, so we don't read it into the, the different case law.
Yeah. So this country, the fact that we still operate capital punishment should give us all pause. And it's not just the state of Ohio, it's the federal government actually has its separate system of capital punishment. And for the first time in 17 years, the federal government executed 2 individuals just this week. And so I think the question we should be asking ourselves isn't, did that person deserve to die for their crime? I argue the more appropriate question is, does our government, does our state deserve to kill? And so much of my research and my scholarship is devoted to capital punishment because of the years that I spent representing men, exclusively men, who had been condemned to die, who society deemed were the worst of the worst. And my task in representing them in post-conviction, so after the trial, after the death sentence, so I'm seeking relief for them in appeal, my charge was to elevate their humanity and bring that before the decision maker, which at this point was no longer a jury, but was a judge or a panel of judges, and to argue that that person, that human being, despite what they had done, despite what they were convicted of doing, did not deserve to die. And so that's where my scholarship is informed from, is that representation. And I continue a very limited practice, but I represent a young man who was 18 years old when he was sentenced to death by the federal government. And we continue to seek relief for that sentence. And so my article, Valuing Black Lives, A Case for Ending the Death Penalty, is looking at the research that shows that the driving factor in death sentencing, yes, the defendant's race has to do with it, but the driving force across the board in these studies is the race of the victim. And so the death penalty disproportionately is sought, so prosecutors ask juries for it. Juries render death sentences when the victim is white. So it's actually regardless of the defendant's race, but it's when the victim is white is the driving force of many of the death cases. I want to be clear, the death row population is still disproportionately Black. Over 40% of individuals on death row are Black, and our population, the Black population in this country is 13%. So I want to be clear, that is still a factor. But the unifying driving force is still the victim's white race. And again, I want to go all the way back to the slave codes, that when the victim is white, the conduct committed against them, if it was a Black actor, could be punishable by death. Whereas when the victim was Black, that was often not even considered a crime. And so here we have in 2020, still the race of the victim is the driving force. And so that I argue, if we're really talking about valuing Black lives, Black people who have been the victim of aggravated murders, where the state actually does not seek the death penalty, they seek it in the white victim cases, we don't need to be operating a system of death, because it actually undervalues the lives of those murdered victims. And so one argument to that observation, to those studies, could be, okay, well, let's increase the death penalty. Let's make sure everyone gets it. That's not where we should end up. Because what we've also seen is that the death penalty results in error. And I don't just mean in innocence, that people who are innocent have been convicted and sentenced to death. I mean that all along the point, there are errors in the legal system with the selection of jurors, with the handling of evidence, the state failing to turn it over to the defense. There are all sorts of errors in the system, even for people that have committed acts that resulted in someone's murder. And some of the issues we talked about just previously, John, that there's so much anti-Black racism steeped in our criminal legal system. And so I argue that the result should not be to increase the administration of the death penalty, but rather to end it. And so to look at certain individual counties across this Cayuga County and look at sort of the rates of the prosecution seeking capital punishment. And my understanding is that Cayuga County's death sentencing has actually decreased over the last recent years. However, the state of Ohio, even though it has not carried out executions, given the legal issues surrounding the lethal injection procedure, I understand there's a governor moratorium, Governor DeWine, but it's still on the books, and you still have people facing death sentences. And so my argument really is that to truly value Black lives, Black victims of aggravated murder, we need to abolish the death penalty. It is administered in a racially discriminatory way, from the defendants to the jurors involved in it and to the victims of murder. And that is a direct descendant from slavery in the very ways that we open this conversation with.